Hello, and welcome to this episode of the Maryland Risk Management Education Podcast. My name is Paul Gehringer, and I'm the Extension Legal Specialist here in the Department of Ag and Resource Economics at the University of Maryland. And today I want to take a little bit of time to talk about succession planning. And it's the time of year where many of you are winding down in the fields, and we need to start thinking about, okay, we got time. One of the things maybe we should work on when we have some downtime in the winter is how do we develop a farm succession plan and some of those issues. And I'm going to use a court case out of Iowa to kind of recognize what can happen when these things don't always work out the way we thought they would when we were developing the plan. So developing the farm succession plan allows the next generation to take over the farm and provides for non-farm heirs is not always an easy task. While you may want to treat your children equally, keeping the farm viable for the next generation may not allow for equal treatment. Why? Dividing the farmland equally may result in one heir getting fewer acres than are needed to support a family. Your heirs are also human and could potentially carry grudges against a sibling. We have to think about that at times, that we're all human and we may, end up carrying grudges. A recent decision out of Iowa highlights what can happen when a farm succession plan fails. In Ghent versus Ghent, Thomas sought an injunction from the Iowa courts to limit how his brother John could utilize farmland John had leased. John had initially leased the farmland from their parents for 25 years. The court decision highlights why families should work to develop plans to meet their goals. There is no one-size-fits-all approach in this process, and families will have to understand that communicating, goal setting, and adapting are essential in this process. Let's talk a little bit about the background. George Ghent leased family farmland from his parents under the terms of a 25-year lease in 2010. His brother Thomas exercised an option after 2010 to purchase the family farmland and notified John that he intended to terminate John's lease as successor to his parents. John went to court to have his lease declared valid, and Thomas countersued, claiming John was destroying the value of the farmland by removing structures and damaging farmland in other ways on the leased farmland, and at the same time that the leases were invalid. The district court granted Thomas' request for a permanent injunction to prevent John from further damaging the farmland, and John appealed this decision. On appeal, the court highlighted Thomas's testimony at trial that John had damaged the farmland by removing soil conservation structures and threatening to treat the land with a chemical to prevent vegetation from growing for 10 years. John testified that removing the conservation structures was done under their father's direction. The issue with Thomas's testimony is it did not match John's history of farming. John farmed not only this family farmland, but other farmland. Given his experience and a history of using good husbandry practices on the cropland, to the court, the 25-year lease gave John no incentive to destroy the family farmland, either by removing structures or spraying chemicals on the land. Thomas, on the other hand, had no farming experience, no knowledge of the current farmland conditions, and was unaware of what their dad had approved for John to do. To the Court of Appeals, there was no evidence John had committed waste and no evidence that Thomas would suffer future injury, which was necessary to give an injunction. So basically, the Court of Appeals overturns the trial court. So why do we care about this? Long-term leases can be one way to allow on-farm heirs to continue to farm family farmland and provide funds to off-farm heirs. Long-term leases also prevent the on-farm heir from using past grudges to prevent the on-farm heir from continuing to lease the farmland. In this case, it's unclear if the on-farm heir wanted to terminate the lease in order to lease to another tenant, take up farming himself, sell the farmland, or just carried a grudge against his brother, John. In any case, canceling the lease without paying damages to the on-farm heir will be difficult unless the on-farm heir has done something to breach the lease. Using some additional tools could help provide fair treatment to all heirs. Families, should consider setting down to develop goals, discuss goals with heirs, everyone needs to be involved in this process. That's a part of the farm and a part of the family. And that is a decision based on what I just said is up to you to make as to who should be a part of this discussion. To make sure, and we need to do this to make sure heirs understand why the family farmland is being transferred to the next generation the way that it is. Then farm families can work with an attorney and other professionals to develop a plan according to whatever has been discussed to allow the farm to continue to the next generation, and at the same time potentially providing for fair treatment of off-farm heirs. If you're interested in learning more about this, I'll provide a link to a page we have through the University of Maryland Extension to where you can look at this and look at resources that could potentially benefit you as you start thinking about this process. Thank you again for listening. If you have any questions, thoughts, or topics you'd like to see covered in future episodes, please email me at lgoering@umd.edu, or you can tweet me or send me a message on Instagram at aglawpaul. Thank you again for listening and enjoy the rest of your day.